We'll get going here in just a second. We're waiting for one more panelist to arrive. They're here, and here we are, I think. Okay. In the meantime, before we get going, Paul, do you have a special announcement to make? There seems to be some confusion with the CPYB and the CLE. I know we're asking people, a lot of people, to put their names on a list, but can you go over that for us?
So just briefly, if you are a certified professional yacht broker, have done the training and passed the test, and you have that designation, you are welcome to sign up on the sheet by Emma's desk out front, and you will receive CPYB credits. If you're an attorney and you need CLEs, then there's another sheet that you would sign up on, and you would receive your CLEs. If you're not an attorney and you've signed up on that sheet, I've been advised while sitting in the parking lot of a Holiday Inn Express that you are engaging in the unlicensed practice of law, and Mr. Jeff Cox would like to speak with you. That is our announcement. Thank you.
Mad dash for the door for everybody to cross their names out. Well, I hope you enjoyed lunch. We're going to get rolling here, and this is a very special presentation, extremely interesting, called The Stages of Arbitration. Consists of 3 parts: the initiating an arbitration, the submissions and hearings, and then part 3 is enforcing an arbitration award. And you're going to be hearing from David Maass and his fellow panelists later. But first, before we tee this up, for the sake of those of you who are unaware of the saga of Bill Boatwise and Bubba Calhoun, we need to bring you up to speed with the up-to-date information about as the prop turns. So ladies and gentlemen, we humbly present the renowned acting troupe, the Low Tides, fresh from a command performance at the Paducah Canoe and Quilting Bee Convention. And if you would play the video, please.
Hi, I'm Bill Boatwise, International Yacht Broker Extraordinaire, and here's what's happened on the last season of As the Prop Turns. You may remember I was the listing agent for the Spicy Meatball, an 88-foot Limoni being sold by the enigmatic Mr. Ficorino, a very experienced owner from Owensville, Missouri. Unfortunately, I was contacted by one Bubba Calhoun, a fishing boat captain from Brunswick, Georgia, who thought he could turn his hand to a bit of brokering. His niece wanted to buy George Clooney's old boat, so her and her husband Chad hired Bubba as their yacht broker to manage the deal and close it out before the end of the financial year. Now, despite Bubba's complete lack of experience, multiple tax and jurisdictional complexities, and a small issue of the boat having been previously run aground, we managed to get the boat through survey, successfully negotiate the final price, and close the sale. However, it all fell apart on delivery day as the yacht caught on fire, sank, and the captain was arrested for intoxication. And now the lawsuits are starting to fly.
Hi, everybody. My name is David Maass. As Bob mentioned, I'm an associate at Maass, Rogers & Lindsay in Palm Beach. On my panel today, I have Michael Karcher of Counsel Robert Allen Law, a lot of experience in maritime arbitration. Andrew High, who is a co-founder and partner at Luxury Law Group, a lot of experience with yacht transactions. And Serena Witter, who's a partner at Robert Allen Law, experienced maritime litigator. And this is going to be a little bit different in terms of the structure of this panel. You just saw the previously on last season of As the Prop Turns, which we used as the basis for pretty much all of yacht sales in the law last year, for those of you who watched. We have 3 more segments of this season, and we're going to play a segment, and then up here we're going to talk about some of the issues that were raised. And then we're going to open it up for questions, and we're going to do that 3 times. At the beginning, I just want to say a little bit about sort of what this panel is about and why we decided to have it. So arbitration basically is a form of alternative dispute resolution where instead of going to court, the parties come together and pick a person who's going to resolve the dispute and pick a set of procedures they're going to use to resolve that dispute. And it's all done privately without the courts. Arbitration has a long history in the marine industry, particularly in the commercial shipping world. At the beginning of the last century, the 20th century, there was a judicial hostility to arbitration, at least in the United States. Courts resented that arbitrators were stealing their business, and they said that arbitration clauses were unenforceable because they were attempts to oust the courts of jurisdiction. And in 1925, Congress passed the Federal Arbitration Act. And that act and a series of Supreme Court decisions interpreting it have made arbitration agreements broadly enforceable in a lot of different kinds of situations, including some that are relevant to us in this industry. A little bit later, there were obviously different national laws on arbitration, different places, and a lot of these arbitration agreements are made between people from different countries. So now, in addition to the Federal Arbitration Act, we have the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or the New York Convention, which is an international convention that allows you to enforce arbitration clauses and also enforce arbitration awards in jurisdictions all over the world, including the United States. Now, the reason we thought we would have this panel this year is that, as many of you know, we've talked about it at some of the other events, IYBA has decided to set up its own sort of arbitration platform that's geared toward the yachting community. One of the major advantages of arbitration is that instead of going to a judge who knows nothing about the yacht industry, you can pick an arbitrator who knows a lot about our industry and the technical side of it, whether that's a maritime lawyer or someone else. I should mention that arbitrator doesn't have to be a lawyer. So we decided that, or IYBA decided that we would set up this platform to enable the yachting community to have access to a roster of really experienced, knowledgeable arbitrators and a set of rules that made sense and allowed us to resolve disputes quickly. And that's being integrated into our contracts, the IYBA form contracts. And so we thought, for those of you who don't have experience with arbitration, we would have a panel just to talk about arbitration in general and sort of how it works from beginning to end, so people would know what to expect and know how to answer questions from clients who may not be familiar with arbitration. Now, I know that Michael has been very involved in setting up the IYAC, the International Yacht Arbitration Council, so do you want to say a little bit about what you're trying to do with that?
Okay, and thank you. And I think David hit certainly the high points. One of the main reasons why IYBA has decided to put this together is, one, this is a unique business, and some of the other organizations that we deal with, the American Arbitration Association, the SMA, Society of Maritime Arbitrators out of New York, yachts are not their business. The AAA, I'm sure they have the best commercial real estate lawyers in the world has ever seen, has arbitrators and such, but in my experience with them is the word boat is not in their vocabulary. Same thing to a certain extent with the Society of Maritime Arbitrators through the years has been more dealing with I always refer to it as blue water and steel decks, commercial claims, cargo claims, things like that. This is a different business and it is a different clientele. And so a lot of the idea was to have arbitrators, maritime lawyers who are in the yacht business, yacht brokers who understand the yacht business. And I think so rather than going to other organizations, we will solve our own problems. In fact, one of the things throughout the 27 odd years of the yacht sales and law seminars, I forget how many years, it's been more than I was there at the first one, so I think the number of years should get shorter, not longer. But the idea was to solve problems. The idea was, what can we do, the people in putting on these seminars, to help you, not just to sell boats at the front end and hope everything goes well, but what happens at the back end should something not go well. And so I think this is an outgrowth of that, the idea that we were putting together our own organization to do this. One, with knowledgeable people, two, with a certain amount of privacy, three, with more keeping it up amongst ourselves. And so by doing that, we have started putting together not just local lawyers and brokers, but we're also reaching out to some of our, European cohorts that we work with, and to try and do this on a more of an international scale and such. And again, it's so we solve these problems ourselves. We are not going public. A lot of you have high net worth individuals as your clients who do not want to go to court and do not want their name put out. Builders, brokers, owners would probably rather not see this happen in public. So that's one of the other reasons we're doing it. So we've kind of put together our set of rules. We've now been setting up training sessions for lawyers and brokers as arbitrators, and it's in place and ready to go. So with that, we're going to, I think with the continuation of the adventures of Bubba, we can see how this works. And then with this panel, we'll kind of discuss the process, how it goes.
Okay, so with that, I think we're ready for Act 1 of As the Prop Turns.
Oh, he actually just walked in. Bill, 1 second. Michael Moore's on the phone for you.
Oh, okay. I'll take it in here. Michael, how can I help you today? Yeah, pretty busy. What's going on? So Chad is not only filing a lawsuit against Mr. Ficarino, but he's included me in the suit as well. The spicy meatball. I knew that POS Limoni would come back to bite me at some point. So, last time I ever let Bubba look over any repairs on anything ever again. Yeah, so Bubba performed him in a negligent manner, which doesn't surprise me whatsoever. What's the good news? So you're going to file a motion to compel arbitration based off the IYAC rules. That's a good thing. Thank God for the IYBA agreement. Michael, could you represent me in this case? No, you can't. Okay. So you can't because of conflict of interest, but I can go to the roster of attorneys on the IYBA list, and I'm sure I can find somebody very suited there. Yeah, for sure there'll be somebody that can handle the case well. Okay. Okay? That's okay, Michael. We'll see you at arbitration. Thank you so much.
This is Yacht Broker Extraordinaire, Bubba Calhoun. May I help you? Oh, hey, Chad. Yeah, hey, Chad, I'm in a pretty busy office right now. Hang on just a minute. Let me step outside. I'll talk with you. Stand by. Hang on. Hey, Chad. Hey, what's shaking? No, man, life is really good, Chad. Yeah, I'm coming out of a mega yacht shop right now. Uh-huh. Yeah? What? Arbitration? What the hell is arbitration? Well, yeah, I'm the one who told you to sue everybody. So, oh, so we ain't got to go to court. Oh, Chad, I tell you what, I'm gonna be your hero one more time. I'm gonna fix this. You fire your damn lawyer. I will go to this arbitration thing and I will teach them boys a thing or two about what's going on in this business. Man, these boys are gonna need schooling till the last day, ain't they? This is ridiculous. All right, I'm gonna fix this, Chad. You stand by your phone. I'm gonna call you with a positive outcome. That's right, Bubba to the rescue one more time. I'll talk to you, bye. God damn.
Okay, so that was Act 1, and we're going to talk about some of those issues at the beginning of an arbitration. So I think to start, Serena, how does an arbitration start?
All right, well, it depends on the rules that we're working under, but usually it involves filing some kind of notice of arbitration to the other side, and that notice of arbitration should include basically the tenor of your claims that you are bringing, the contact information of the other side, the respondent, and basically just outlining why this arbitration panel has jurisdiction to hear this dispute, and basically notifying attaching the complaint that has the arbitration provision that gives the counsel the jurisdiction to hear the dispute. And basically that's how we get started with the notice of arbitration.
So that's how it's supposed to happen. In the video, it didn't quite work that way because despite the arbitration clause, they just went ahead and sued the other party. When that happens, when you have an arbitration agreement, someone sues you anyway. Michael, what can you do?
Okay, and I do want to back up to one point. It was kind of, we have to be, having a serious discussion after watching that, just keeping a straight face. But having said that, somewhere in there, we're going to refer to an arbitration clause. The first step, even before what Serena was saying, you were asked how to initiate the arbitration. What happens before in time is you have agreements. You have a listing agreement, you have a purchase and sale agreement, and that arbitration clause is in there. I sometimes think, most people look at the contracts and they go to the important things, which boat and how much, and those dates. Back towards the end, you have those sections, dispute resolution. As lawyers, we don't always, we turn to the back pages because we don't always have those happy thoughts that it's going to go perfectly. But what happens when something doesn't go well? In the new IYBA listing agreements and the purchase and sale agreements, the form ones, you'll see, I believe it's clause 17, gives you the whole layout of how to get here in the first place. Because, and you've entered into a contract with someone, the buyer and the seller have entered into that contract, and should it not go perfectly, there is a provision on how we're going to resolve a dispute, which leads us to arbitration. And you have the choices of no arbitration, you can go to court, either choosing either the London arbitration, I think now we have it, you can choose the London arbitration, or if left blank, it automatically, if you haven't checked off going to court, it goes to the IYAC and such. So you have or the parties have agreed to arbitration beforehand. So it's important to read those back pages. And so that's why when Bubba says there's an arbitration clause in it, that's how you get there in the first place, or that's how you set it up. So should there be a problem, and then is there a problem, then, as Serena was saying, you initiate, someone's initiating the arbitration, they're saying, we have a dispute, something went wrong, we're not happy. And rather than suing someone, hopefully rather than suing someone, we go to there's an arbitration clause. What happens now getting to Dave's question, so long-winded around, what sometimes happens is someone says, I'm not happy, sue the person. And sometimes that's not the colorful phrase. And often than not, the respondent, the defendant, will say, you know, you can't sue me, there's an arbitration clause. In fact, around 2005, I was involved with one of the cases with a FYBA purchase or actually listing agreement, which buried down at the bottom had an arbitration clause. We were, you know, and it was a boat that was in the care and custody of a broker. So they sued the broker, and the broker was also listed in it. So the broker was able to say, we have an arbitration clause. One of the US District Court judges here over on Broward Boulevard looks at it and says, you guys made the deal, there's an arbitration clause, get out of my courtroom, go arbitrate. So that leads to, that leads to the initiation. So it's often used as a defense right away when someone wants to sue someone and saying you can't sue. You already agreed to it. You put in a contract. You signed it. So then we get to arbitration. So
If you go too far down the road of litigation without bringing up the arbitration clause, though, can you waive your right to compel arbitration?
you can, but it's got to be somewhat pretty far down the road because it is almost a defense to it right off the bat. At some point, you know, the judge may say, you're all here and you had your shot. So it's something you want to go to, you know, I want to say quickly. And you know, once you look at the contract and someone starts looking through it, or your lawyer starts looking through the contract, I know it's happened several times with some of us where someone says, I want to sue someone, you can't. Or, you know, we've been sued, you know, well, we're going to, you know, one of these arbitration agreements. So, but it's usually raised fairly fast because that's, I sometimes jokingly say, but I mean it, I think that's sometimes the first time people really study those back pages with things like venue, where are we going to do this, you know, what jurisdiction, what law are we going to use, you know, all of those things that on the back pages that only lawyers look at.
So one thing I want to mention is, you know, Michael said that to force somebody to go to arbitration, there has to be an arbitration clause in the contract. The other thing you can do, if both parties would prefer arbitration, even if the contract doesn't say anything about arbitration, once there's a dispute, you can always agree sort of ad hoc, let's arbitrate this. You know, this is a complicated technical question. We would much rather do this in front of someone who knows our industry than in front of a judge. The problem with that is that usually once there's a dispute, one party has a perceived advantage to arbitration or a court. You know, a party with a weaker claim may prefer to bring it in front of a judge and jury who doesn't know anything about maritime law or our industry. And so when you're agreeing on a clause ahead of time, you're sort of behind a veil of ignorance. You don't know what the dispute is going to be. And so you're more likely to agree. But you can't, there's nothing to stop you from agreeing to arbitration after you've signed the contract. Michael also talked a little bit about arbitration clauses, different arbitration clauses in different contracts. Andrew, when you're reviewing a contract, whether it's an IYBA form contract or any kind of contract, what do you look for in a dispute resolution clause?
Sure, so usually we're just looking at what the vehicle is for that dispute resolution. Is it the IYAC arbitration? Is it, you know, court in Broward County? The one that comes up most often is the London arbitration clause in the IYBA agreement, because you and I agree to charter a boat, let's say, and we're both here. We have no idea that we agreed to you know, arbitrate in London and hire London lawyers to do that. So I like to point it out because you just say, hey, is this something that you consent to beforehand? And sometimes people are more than happy to do it. Sometimes they're not, right? And so then we can make that change up front. But that's mostly what we're looking at is where is it, what's the dispute resolution, and then also, not so much with the form contracts, but with other contracts, is there an advantage to my party to having this type of dispute resolution, or is there a disadvantage? Because we might change it then.
So, I mean, my experience with the LMAA clauses in particular has been that it's usually just a deterrent to any sort of, you know, it leads people to settle because they just don't want to pay to go to a LMAA. Yeah. Although sometimes if you have parties from different countries, it can be good to choose sort of a neutral site like LMAA rather than, you know, so one side doesn't have home field advantage. There are, I guess I should pose a question. Are there ways of avoiding arbitration if someone's trying to enforce an arbitration clause against you? Serena.
So going back to basically arbitration is a creature of contract, right? So that is the start point. And again, we brought up that you can actually agree to it after the fact in terms of if we agree, this is what arbitration is going to look like. So as far as getting around arbitration, a few defenses can be, number one, that the contract that's you know, up for dispute, either that's not an enforceable contract, There's issues with execution of that contract. There might be issues with who the parties were that signed that contract. So you can basically attack the contract that's being the subject of the arbitration. That can be one way around enforcement. Another way around it, and it's a little bit philosophical, but you can also argue that the dispute is actually going beyond the scope of the contract, in terms of what we are arguing about actually has nothing to do with that written piece of paper. It actually has to do with something else, something arising out of tort, per se. So there are some ways around it, but at the end of the day, the judge or the arbitrators will look at the cold facts of what the contract says, what the parameters are of the arbitration agreement, and they will determine whether or not that dispute is going to falls within that language.
So one of the things you mentioned is an arbitration clause usually has language that says it applies to, and it usually is anything arising out of this agreement.
Correct.
But you could decide that you only want certain kinds of claims to be subject to arbitration. So
Absolutely.
we often, like for example, in new build contracts, if there's a question about a technical matter, you might want to refer it to a technical expert rather than go into full-blown arbitration, whereas if there's a legal question, you want to take it to arbitration. So I think the language in the IYBA forms is fairly broad, but you certainly can narrow the scope of claims that are subject to arbitration. Michael, are there any claims that by their nature can't be arbitrated? Are there any kinds of claims that you can't arbitrate?
Well, again, it comes back, I think, back to what Serena said. If you put it in the agreement, I mean, I think within reason, we can agree to have someone arbitrate just about anything. I mean, you can take out certain things, criminal matters, things like that are outside the scope of the contract. But generally, it's what's within the contract. It's with the scope of the contract. And if it's something that's, the purchase and sale ended here, but we still have a dispute over here, or it's, the owner and the buyer and the seller got into some kind of argument having nothing to do with the boat, that's not, that would not be something arbitratable. But theoretically, and some courts will look at it and say, y'all made the agreement. You decided, you paid your money and you took your chances, you go do it. So I think that's a lot of it in terms.
And what if, in the IYBA agreement, primarily it's buyer and seller, but the brokers are also a party to that agreement.
Correct.
So if there's a dispute between, say, the seller and the brokers about commissions, would that be subject to arbitration?
That can be subject to arbitration.
I mean, this I guess I haven't thought about this. What if you had a listing agreement or a commission agreement that had a conflicting arbitration clause than the one in the IYBA purchase and sale agreement?
Well, it may become a question, which did it come out, it may be a
Right.
chicken and the egg question. Did it come out of the list, is our dispute, and often sometimes the listing, the dispute with the broker may be in the listing, but the dispute between the buyer and seller may be in the purchase and sale. One of the things under how the rules are set up is the arbitrators have almost the discretion to decide, is this within our purview? Is this something we want to hear? And courts will uphold that because you agreed to those rules. And in those rules that are not attached, the buyer and seller may not have read, but the rules will say the arbitrators have the discretion to decide what they're going to hear and what not. So most things are going to be, they're going to decide.
So that's an important point, what Serena mentioned earlier about, is it within the scope of the arbitration clause? If someone sues you and you try to enforce the arbitration clause and they say, well, this isn't within the scope of the arbitration clause, the court is going to say, well, that's for the arbitrators to decide.
More often than not.
I'm not going to rule on that. Andrew, when you're talking to clients on a transaction who have questions about sort of arbitration, first of all, what kind of questions do you get from clients, and what do you tell them about when arbitration is a good idea or what kind of arbitration they should choose?
Yeah, so when we get that question, which does actually come up a fair amount, it's what's the benefit to me? Is it time? And more often than not, it is. Is it cost? Probably more often than not, it is. And then I like to hammer, it's just a personal experience that we had about not quite 15 years ago. We had an arbitration in front of the AAA with a commercial arbitrator who was a very smart guy that I've never run into since, but had no experience in yachting, right? And the crux of that case came down to a nuance between the YBAA agreement and the IYBA agreement. And we spent our entire arbitration trying to explain this nuance and industry standards to this arbitrator who was not getting it. And we ultimately lost, and maybe we could have done a better job explaining it. I thought we should have won. I thought we did do a good job. And so, that's case in point for why this works. It makes sense. And so when we talk to clients about it, I like to use that example, as to getting in front of people that know at least a baseline of knowledge about our industry so that we don't spend time, money, effort trying to explain something to somebody who's just a wall and not getting it, and then we ultimately lose. I think you control your outcome a little bit better, your possibility outcome better by doing it that way.
Rob often says that a client's preference for arbitration or litigation usually depends on the outcome of his last arbitration or litigation. Yes. So some people have had bad experiences with arbitrations that were very expensive and they lost. Some people have had good experiences with litigation that they won relatively cheaply or the other side paid their fees. But I think one of the goals of the IYAC is to set up something that's going to be, allow you to resolve disputes relatively inexpensively and quickly, right? So hopefully people will have good experience with it. I think I wanted to leave a little bit of time for questions before we go. We're going to have questions at the end of each of these before we go on to the next segment. Watch the next video. So if there's any questions anyone has about sort of arbitration agreements, enforcing them, how you end up in arbitration, now's the time.
And Craig Nance.
The newly revamped IYBA paperwork has added a mediation clause. What's your opinion on having that out in front of arbitration?
When he says a mediation clause, some of them will say you must mediate first, and if you don't reach an agreement, then go arbitrate.
I think that's what the IYBA agreement states.
I think mediation's not a bad thing. The difference between mediation and arbitration is mediation, we get the two of you together, and the mediator acts much like a broker. What are you willing to do? What are you willing to do? Can we make an agreement? But he has no authority to say that's the agreement. And if they can't make it, it's like, hey, we tried, thank you very much, go arbitrate. I think sometimes it's a good thing. It usually happens fast, and it's, can't we work this out one last chance before you go spend more money on arbitrators and such. So it's still in their hands.
What I don't like about it is that you're forced in that agreement to do it now, and there's other agreements that have the same kind of provision. In any agreement, right, even if we have an arbitration clause, you and I can agree to mediate before we arbitrate. We can always do that. And so, you might have seen me on the computer earlier out in the hallway. We were doing a mediation, a pre-litigation mediation, where the parties agreed to mediate, and we actually resolved it today before incurring a whole lot of costs. That's great. You can do that, but sometimes making it mandatory just wastes time and effort. Because we go into mediations all the time, where there is no conceivable chance that these parties are gonna, and now we're just wasted time on, lawyer time, fees, costs, and just time in the lawsuit to go through this little exercise.
Mediation.
You want to break the tie?
Think of divorce. Ask me how I know. Any other questions?
How does the IYAC decide what to hear and what not to hear? And second part, how do you or who chooses the arbitrator?
My somewhat second answer may be, that's chapter 2. But having said that, it's almost the other way around. You, the buyer as the seller, choose to use the arbitration. I mean, we don't go out, on the street, waving a sign saying arbitration is, we'll work for arbitration or we'll arbitration for food. But the idea is, you have made that choice. Now, there may well be things where, if it, that a panel can say, we're just not going to hear this. And actually it's within the rules. I don't know of any really times that's happened in other organizations and such, but it is possible. Maybe, I got to admit it, my imagination's going wild at the minute.
You guys would maybe, choose if you're going to hear something or not, if it's something that would go to
within the
arbitration.
and now it's, yes, okay, to that, okay, I see what you mean.
So I didn't know if there was a panel of people and you guys.
I thought just
said,
admit, like, I don't want to hear
Are we
you.
going to arbitrate this, or no, you guys can figure it out on your
If
own?
it's something, let's say it's under a purchase and sale agreement, the agreement for something didn't happen right, or something wasn't included, you said, you didn't have the complete list of equipment, you did, something. Those things are within, but if, and in the middle of it, you you slandered my crew, made some kind of, you were in an EEOC thing a while ago, you've said terrible things, whatever. We might say, that's outside of the contract. One side may say, I think it's outside of the contract, and we'll say, yeah, this contract is not about whether we hurt the captain's feelings or something like that. We're not going to hear that, something. We try and keep it to the contract. There may be things that were outside of that someone says, well, we want you to handle that as well. No, that's not part of this. That's more of a, I think Serena said, a negligence thing or a tort thing or some kind of personality conflict between buyer and seller, and that's outside the scope of the contract. So that's where that's where that decision would be made. Does that sound right?
Other questions?
Yeah.
David?
Act 2.
Okay, is everybody ready? All right, thank you everybody for coming today. We're here to resolve the dispute of the sale of the spicy meatball. In these proceedings today, the buyer, Chad, is the claimant, and the seller and his broker, Mr. Ficarino, represented by Mr. Moore, and Bill, represented by Ms. Stanley, are the respondents. The proceedings today will be conducted under the International Yacht Arbitration Council.
I can handle that.
Ladies and gentlemen, they have a very interesting case to be brought before this esteemed council, and here are the facts as we know them. Before closing, the yacht was damaged by a lightning strike, and the respondent repaired the damages. The claimant alleges that the respondent failed to repair the damage in accordance with sound marine practices, and that the deficient repairs caused the fire that destroyed the spicy meatball shortly after closing. And these are the facts as we know them.
Mosquito in here.
So the arbitrators have had a chance to review the parties' written submissions. Is that correct, gentlemen?
Yes.
Thank you. The seller, Mr. Ficarino, has requested an oral argument. The arbitrators will first hear from Mr. Michael Moore. Might you have anything to say, Mr. Moore?
Thank you, Mr. Arbitrator. I appreciate this opportunity to bring our case before the International Yacht Arbitration Council. And we're mindful that all three of you are experienced and seasoned members of the, the yacht community, the yacht world, as it's sometimes called, or the yacht industry. So we were, in my view, I represent a man named Ficarino, who was a seller of a motor yacht. Frankly, he did everything right. The only thing that's wrong in this action is that we were sued in state court in an inappropriate manner under the purchase and sale agreement for the yacht that he sold to these two buyers who were in all respects treated properly. The seller in this case, Mr. Ficarino, the first thing he did properly was he signed a listing agreement with a licensed yacht broker in the state of Florida, Mr. Bill Boatwise here, represented by Ms. Stanley. And that was the first proper thing to do. And the sale was conducted according to law and according to the purchase and sale agreement. One of the mistakes that the seller made was he hired an unlicensed individual, an unlicensed broker, a man with if I may say so, a bit of a checkered past. Okay, we don't mean to impugn his, character, but he's not a licensed member of the yacht brokerage world. He's not a member of the IYBA, and the things that have happened in this matter proves the downside of that type of behavior. Stated simply, we had a proper transaction. We went to, the buyer went through due diligence. It was his decision to how he wished to do his due diligence. He had a survey. The survey discovered deficiencies. The deficiencies were identified and they were repaired. And he accepted the vessel. And he accepted the vessel as is, where is. Those words have meaning in the yacht world as well as in the law. And went to a closing, and at that point, the risk of loss passed to the buyer. Ownership, possession, and title passed to the buyer. And it's just unfortunate that after ownership, possession, and title had passed to the buyer, there was a situation that it resulted in the boat exploding. The vessel, of course, because of the explosion, caught fire, and the vessel sank. So that's all on the buyer. There is no dispute here, no legitimate dispute, so we have petitioned this tribunal through the IYAC to rule in Mr. Ficarino's favor and to end the award, to specifically set forth that there is no claim, there is no proper cause of action, and this matter should be dismissed.
Thank you, Mr. Moore.
Thank you.
Now let's hear from Bill's attorney, Ms. Stanley.
Thank you. Good morning, Chair and esteemed panel. I'm Jo Colbert Stanley. I'm here today representing the co-respondent, Bill Boatwise. Frankly, and to be blunt, I'm not sure why we're here. And I won't bother repeating the eloquent profferings of Mr. Moore. You know the facts, you've read my submissions, you've looked at the exhibits. And Mr. Boatwise had no duty to the buyer, who isn't even here today, by the way.
He don't need to be here.
My point being that this case was brought frivolously, intended to harass my client, and absolutely overlooking all logical legal concepts. For this reason, I'm submitting that you dismiss my client and award attorney fees on behalf of my client to be paid by the claimant
Good luck
to
with that,
Mr.
lady.
Boatwise. Thank you.
Thank you, Ms. Stanley. Now let's hear from the claimant, represented by Bubba.
Well, nobody told me I was going to have to submit nothing. Could I use a pen and a paper? Do you need a submission? Because if you don't need something in writing, I'll just tell y'all how it is. You know, y'all with your fancy letters behind your names and all that stuff, you need to understand you're in for a fight. Because I have watched every episode of Boston Legal, and I have watched Law and Order from beginning to end. So I know what I'm doing with this legal stuff. Now look here, waste a bunch of money on lawyers. I don't understand it. It's all right if I talk myself, ain't it?
Yes, it is. You do not need to be represented.
Well, good. Because here's what y'all need to understand. Ain't none of y'all never drove a boat. Y'all ain't never worked in a boatyard. Y'all ain't never drove a boat. You don't know bupkis about what it takes to keep a boat running, keep a boat working, and when it breaks, how to fix it. It's simple. You get a good guy, you get his tools, you get on there, you fix the problem, you move on down the road. And I don't know what y'all are making this big fuss about. I didn't do nothing wrong. I didn't do nothing wrong at all. Mr. Ficarino's boat was broke. Lightning struck. It blew up. It's just that simple. Res ipsa lipitor. Danny Crane. You know, the fix is in with you guys. Go Dogs. Good luck with this. When you figure out I'm right and you're wrong, you give me a call. I ain't wasting no more time with a bunch of this BS. Have a nice day.
All right. Yes. Well, Mr. Calhoun is apparently done. Mr. Moore, do you have anything else to add?
I just want to say that I appreciate your service here today. I think that one of the wonderful things about the IYAC is contrary to Mr. Calhoun's slander that the fix is in. I think that we are quite confident that this case will be judged on its merits, for better or for worse, and we will accept the ruling of the tribunal. I would like to join Ms. Stanley in a comment she made earlier. I think she's absolutely correct. This case, because it has no merit and because there's a provision in the purchase and sale agreement, and also within the equitable powers of this tribunal, we will be asking, if the ruling is in our favor, we will be asking for attorney's fees. With that, thank you very much for your attention and consideration.
Thank you.
Okay, so there's a lot to talk about in Act 2. Let's start with the arbitrators. Michael, how do we pick the arbitrators?
well, first, I want to say, we use the phrase, we pick the arbitrators. Actually, you pick the arbitrators. There is a list of arbitrators within almost all organizations, and certainly with the IYAC. So when the petitioner, as Serena put forward, initiates it, the parties are given a list. Depending on the size, dollar amount, complications of the arbitration, it can be a single arbitrator, it can be a 3-person panel. If it's a 3-person panel, the petitioner picks one, the respondent will pick one, and then those two agree on the middle person. And if it's a single arbitrator, then usually the petitioner will put out a name. Here are 3 names I like. Do you like any of them? If not, we'll come up with 3 more. And they'll work it out. They actually agree. And the final line on that is if the parties can't agree on one, or the 2 can't agree on a middle person, I think it's 2 weeks, then the panel will pick one. The IYAC, the board will pick one for you. And we've seen it a couple times in other arbitration panels. A lot of times we'll say, if you 2 can't pick one, we're going to pick one for you. And sometimes what I like doing is saying, and we think Andrew High would be the person. So that way they even have someone to rule, to say, oh, it's him, or, okay, we'll take him, or we'll pick one. But it's actually, you pick them and you agree on them. Okay.
And Andrew, so 2 questions. One is, first, 1 arbitrator versus 3 arbitrators. Do you have an opinion about which is better? What are the pros and cons? And then second, sort of what are the criteria you look for when you're choosing arbitrators, who to appoint?
Sure. So the first part of that is who to appoint, right? You're looking for somebody with specific skills or knowledge related to your claim. If it's a contract claim, with the IYBA, then somebody that knows the contracts, a lawyer. But you're right, it doesn't need to be a lawyer. And so it could be somebody with specific, engineering knowledge or brokerage customs knowledge, and we would look for that. The 1 versus 3, it depends on the type of claim. I like the concept of I appoint mine and you appoint yours and we appoint a 3rd. But I don't exactly know how the fee structure works for this, but there are fees associated with hiring arbitrators, and you've just tripled your costs once you've gone with three arbitrators. So for smaller claims, a single one generally works, and when people start to look at costs associated, they may want a single one. The one thing I'll say, Mike and I talked about this yesterday, was there's benefits and drawbacks. There's a huge benefit to having somebody in this industry that knows our contracts, right? The drawback is this is a small industry. You're probably going to know the person sitting on the other side of the table as you. And that can be good or bad. Not that that person is going to be biased in your favor, but you may not be comfortable telling somebody, the nature of your claim when you know them or you see them personally. And it's a small pool right now. And so you're probably going to know the people that are appointed from this group.
So Serena, sort of pivoting off that, it's small industry, often we've done business with each other. How in arbitration do you handle something like conflicts of interest or challenging an arbitrator who you think might be partial to the other side?
Sure. So this goes part and parcel with, first, hopefully, the parties are able to agree with who's going to decide this dispute as far as the arbitrators are concerned. I tend to look at it usually when there's a challenge to an arbitrator. There's a bit of a concern that that person may not see things their way, right? In terms of just that's the cold reality of litigation. But as a party, if you've presented your list of arbitrators, and for whatever reason, if somebody who has been appointed or selected, you feel is going to have some sort of bias or for some reason can't be impartial, you are able to challenge that selection. And again, you have to present reasons other than, I don't think this person's going to rule in my favor. That's, everybody that's listed, usually they're going to be professional. They're going to be able to put aside whatever personal feelings are and just decide the dispute that's before them. But if for whatever reason, you need to be very clear and particular as to what are the reasons why you believe that this person cannot be impartial and decide this dispute. The more specific, the better, as far as that ruling being upheld. So there is a procedure in place in order to challenge an arbitrator.
So, Michael, I think that's something that's built into the IYAC rules.
It is built into the rules where the provisions, the ability to challenge an arbitrator. And generally what also happens when, the arbitrators are picked, they will send basically a conflict check. I know the respondent, I don't know the respondent, I know who he is, I've worked with him once before. If it's a lawyer, I dealt with their firm, a year ago, 10 years ago, 20 years ago. So everybody knows, so there are no surprises when I find out, if, I pick Serena as a arbitrator and the other side doesn't know that, halfway through goes, wait a minute, you guys work together or something like that, or that's your brother-in-law, that type of thing. So they will put out a conflict list and such. And if you don't agree, and frankly, a lot of arbitrators will say, hey, if you're not happy with me, no, you're not going to hurt my feelings. Thank you very much. I've seen some ones with the AAA where someone raised a conflict and the arbitrator said, okay, thank you very much. I don't think anyone's fighting to be in there at times. So
I'd say too, though, I think if you think that there's, I don't know, if Serena's on the panel and she just doesn't like me, and I think, well, she might not rule that way, that is a benefit to 3 arbitrators over one, right? Because now you got to build a consensus for an award, and one person can't just railroad it if you think that they don't like you or they don't like that type of claim or whatever it is. So there can be a benefit there to that.
I think that's a really good point, because even if it's not a relationship with another one of the parties, you don't know what kind of prior experience an arbitrator has had that may predispose them toward a certain outcome or viewing the situation in a certain way. And so when you have 3 arbitrators rather than 1, the risk goes down that something like that is going to sway the result. Michael, could you talk a little bit more just about sort of the IYAC rules and the procedure? What happens once the arbitrators are chosen? How does it work?
Generally, and after, I think as Serena said, the initiating documents. Someone is sending, at the very brief, we're suing on this contract, it's attached, here's what the dispute is. The respondent will file an answer and a response, somewhat similar to in a court, may have some defenses. If there's any counterclaims, they may raise them. There is a fee involved with that. And the petitioner, now counter-defendant, will respond. Once it is in, they will then pick their arbitrators. Once the panel is established, either the single arbitrator or the middle arbitrator will set a kind of a preliminary hearing date. And at that, it's a schedule, more than anything else, it's a scheduling conference. Ladies, gentlemen, what is this all about? Who's suing who for what? How long is it going to take? What, do you want to do this just on paper? Is it something, if it's in a builder's contract, I've seen ones where just a single arbitrator or someone's picked, a paint expert. Is this good or bad? Is this what he wanted? Or something. Or if it's a full-blown one, are we going to need, is it just on paper? Is it just on documents? Are we going to need witnesses? If we are going to need witnesses, how much are you going to need? And kind of and that's literally a scheduling conference. How long is it going to take? What do you want to do? Let's move this along. And so we know setting up the rules. Paperwork will be in by, next week. Any discovery that has to be taken over the next couple of weeks. Final hearing date on, X date. Let's go forward. But there's a certain amount of, if there's an overriding theme to this is your arbitration. You two can decide how much or how little, within reason, you want to push this. Are you going to need are you going to need witnesses or not? Some things can be just done on paper. Heard on the Bubba thing. I didn't know there were submissions or such. Usually people are putting in their contracts and such. But that scheduling conference gets you to, is there going to be any discovery? And then we'll have a hearing.
So I want to stay with that subject of discovery. In litigation, discovery is this process before trial where you can request that the other side produce documents and you can depose witnesses and you sort of get more information about the dispute. How does that work in arbitration? If there are documents that are in the other side's control or you think there are emails that could help your case that they have, how do you go about getting those in an arbitration?
Want to take that?
Well, I would assume it's in the IYAC rules as to what you can do in terms of discovery. And if there was some sort of, let's say, failure to produce, you would have the arbitrator.
Right. And after, much like a court. I mean, and at that initial conference, we'll decide, how are we going to do it? Are we going to allow, interrogatory or questions, requests for productions and such? And if there's a feeling that someone is not producing it, and arbitration panels have the ability to issue subpoenas, and Overriding that is if there's a feeling that one side is not cooperating, that will certainly have something to do, much like in a, I don't want to say in a real court, but in a state court, where they will have the ability to have that either influence the decisions, or you have not produced it, you know, it doesn't necessarily rise to a default, but it may. But the arbitration councils have the ability to issue subpoenas and such. The one thing, again, about in arbitrations, these are generally parties that are working, that have a contract and a relationship together, as opposed to you and I just ran in, you know, on the way out of here, and we, you know, had an accident out on A1A, and I never met you from before. So there's a certain amount of, I think everybody knows a little bit about the business anyway, and what documents were there and what documents are not there and such. So a lot of times that plays into it. I think when you talked in the beginning in terms of, you know, these were, you know, commercial organizations and such, much like the insurance clubs, everybody knew each other and such, so they were working together. I mean, the buyer and seller, while they may not have known each other beforehand, they have a business relationship going in. And so sometimes that helps how much paperwork, discovery, things that are, you know, are produced. And then you have the ability to, you know, just like a regular court case, people will set depositions if necessary. Some, you know, and it's depending on the size of the case, the nature of the dispute. Depositions can be set, and, you know, we get to a hearing.
You mentioned, you know, if one side refuses to produce a document or produce something requested by the other side, I can't remember if this is in the IYAC rules, but I'm assuming that the arbitrators would be able to make an adverse inference.
Oh, absolutely. Yes.
Right. So basically, if you're not disclosing something, it must be because there's something bad in it. So we're just going to assume that it's bad for you. When you go into an arbitration, it's good to have, you know, as much support for your argument as you can, so it's not just you making these assertions, particularly when it involves something technical or where there's some sort of, I guess, objective issue as opposed to just disputing what a contract means. Andrew, what kind of things do you like to have? Expert reports or testimony? What kind of things are helpful in an arbitration to win your case?
Depends on the nature of the claim, right? But you know, if it's a technical thing, certainly expert reports. You know, depositions of people involved, so that we get, you know, number one, we know what you're going to say and what you thought at the time, what you did. So depositions sometimes are helpful. Expert reports. Sometimes industry specialists, which are more like the expert, but in a different way that you might be thinking, right? Not this is how you apply this paint, or this is a good, you know, application. You might be what's customary for brokers when splitting a fee. What's customary for brokers in terms of work done, you know, when assisting another broker. You can get expert testimony that's not just technical, right? And so sometimes that becomes helpful too. And then, you know, generally we're looking for typical discovery stuff. We're looking for emails. We're looking for a written record of what happened here, text messages. Everybody uses WhatsApp. I want to see them, right? You know, those things are generally helpful with any kind of claim, not just arbitration, but we want to see what you saw from the other side, so we know how strong our case is.
And Serena, as a lawyer, when you're approaching an arbitration, how is advocacy in an arbitration different from, say, trial advocacy? How is your role different, if at all?
I treat it the same as far as arbitration. The magic of arbitration is a lot of things are like court, and so you're not really losing anything by going to arbitration in terms of a lot of the rules are the same. A lot of the way the discovery progresses is the same. And so as far as our advocacy, it is exactly the same. And in fact, an interesting aspect of arbitration that's an addition that's not usually included in court is the ability to just be able to decide on the papers alone. Arbitrators can also decide to just accept witness statements instead of, you know, sometimes having to schedule a trial. First of all, in court, you don't really get a court date until very, very soon before trial. And you basically have a 3-week trial calendar, and you're telling all of your witnesses, hey, you have to be available, you have to keep all of these 3 weeks open because we're not even sure when trial is going to be called. I mean, that's a scheduling nightmare, not only for your fact witnesses, but also for expert witnesses that you are paying by the hour. And so the ability to basically have your witnesses submit written statements That's huge. That's a huge, not only just for convenience, but for cost as well. But as far as advocacy, we go to bat regardless. So you're not really losing anything by keeping more of the control within your purview rather than, on the other hand, when you're going before court, once you submit that complaint, you have no idea who your judge is going to be. That's basically on rotation, chosen by the clerk of courts. And for things that aren't maritime claims, a lot of those claims are going to go before a jury. And that can be a wide range of individuals as well. So as far as being able to have a say in who decides your dispute, arbitration is definitely, hands down, a much more controlled atmosphere.
And Serena, staying with you, we've talked a little bit about having decisions made just based on paper submissions versus requesting oral argument or having live testimony.
Right.
Under what circumstances do you think it's beneficial to request oral argument or live testimony, and when are you content to just have it done on the papers?
That's a great question. It really depends on the situation. I think the cleaner case you have, if it's a pretty open and shut case, then I'm perfectly comfortable with submitting things on the paper. If there's a more nuanced issue and you're not really sure if the arbitrator is getting it, you might want to have an oral argument so there can be more of a back and forth conversation. If I'm not sure if things are making its way through, then at that point I'd rather request oral argument so that I can get some feedback from the arbitrator in order to see if my position is getting through. So it really just depends on the situation. But either way, at least that's an option in arbitration.
Michael, when the arbitrators are listening to these arguments and trying to make a decision, what law are they applying?
Well, first, going back to that initial contract, your initial contracts will also say, this contract is controlled by the law of the state of Florida, or whatever you choose, depending on where the parties are from, and such. So that decision has been made generally beforehand by the parties. The purchase was here in Florida. You two have agreed to use this law of Florida. Where one of the things Serena said gets into in terms of evidence, arbitration is a little looser, though, in terms of it is not controlled strictly by the federal rules of evidence. It is up to the discretion of the arbitrator. So we're willing to accept written statements from the people as opposed to having to drag someone there. I mean, if one side or the other thinks it may be much more necessary to bring someone in. But otherwise, we're willing to take written statements. You don't have that, oh, this piece of paper here has to be authenticated by, whoever, if it's a public document and such. There's a certain amount of, yeah, it looks real enough, or something, where it's known unless it's challenged. So it's to smooth out the process, make it run a little faster and such. So that's one of the things in terms, I guess, the arbitrators are going to be looking at. But a lot of it's up to their discretion as well as to what they hear, or as I've heard judges say, and some of the other lawyers in the room have heard, where someone submits something and it may be questionable whether it's a tad of hearsay or something, and the judge may say, I'll give it just the weight it deserves. And there's a little of that. So the arbitrators will do the same.
And I guess that it's obviously, the federal rules of evidence are incredibly complex, but there's also some benefit in that, for example, in arbitration, you don't necessarily have a right to cross-examine witnesses, and if you want to attack certain information, say this is irrelevant or should be excluded for this reason, it's really up to the arbitrators.
Right. I mean, if it's something on paper and it's submitted beforehand, they might want to submit something against it. But if it's a live witness, it's just like going to court. Call your next witness, question, cross-examination, question, little rebuttal, thank you very much, and such. So to that end, with live witnesses, it's very much like a court case.
Mm-hmm. And Andrew, what's your experience been? How would you compare arbitration and litigation sort of generally?
I mean, the feel is more informal because you're not in a courtroom, right? There is no jury. If you're thinking of like what you see on TV, it's not like that. One thing as I was preparing for this, kind of thought of my experience of it is it's more personal. And you can kind of see it in the video. It doesn't, maybe something you're not looking at, but I'm sitting, about as close as I am to Mike, and I'm sitting, about as close as I am to you, and the arbitrators are right on the other side of it. And it's very personal because we're all in this little space. And so to that end, it can sometimes be a little bit uncomfortable just because if you're really adverse to this person that's sitting right next to you, and granted they do try to separate you just a little bit, but you're in a very small room, and it does feel more informal and personal than a court case does, where you're kind of you kind of give into the airs of the courtroom where there's a table and a table, and the judge is 15 feet in front of you and sitting on a bench. It's just a little bit different. But in that regard, it's uncomfortable, but also comfortable because it feels more familiar and less combative, even though you might not like that person sitting across from you.
And Serena, I'd like to ask you about something that's not a part of the story that we're watching, but is often something that's happening or may be happening, which is settlement. You can always settle a court case. You can settle during an arbitration. When does settlement begin to look attractive? How do you know to identify an opportunity to settle rather than going all the way through to the award?
Great question. That is usually just up to the client as far as my ability to manage the client's expectations. I always try to see if there's a way to settle the matter, because going all the way through, whether it be litigation or arbitration, is going to be an expensive endeavor, right? So usually one of the first questions I ask about the dispute is, how much is that issue? Meaning, how much are we fighting over? And that usually will start to dictate a lot of my not only litigation negotiations and strategy, but settlement as well, in terms of, look, at the end of the day, if we're fighting over $10,000, $20,000, and you're looking at multiples of that, if you're going to take this thing through whatever process, I will start telling my client as far as, look, how angry are you? And what are your goals in terms of, do you really want to, if you've been wronged, do you really want to get that damage amount back? Are you just trying to use litigation as a leverage tool? Are you just trying to punish the other party? All of those things come into consideration and govern my ability to see how we can settle this thing. So those are things that I actively look for regardless of the form that we are in. But definitely, yeah, the amount at issue and what are the client's goals.
And it can be really attractive, because one of the things we'll talk about in the next segment is enforcing an award. But if you have a counterparty who you think may resist enforcement, obviously settlement, you have money in the bank before you agree to drop the arbitration.
Absolutely. Absolutely.
Okay, so I wanted to leave a little bit of time for questions after this segment as well. So are there questions from the audience?
Paul, over here.
Paul?
I'm coming.
How much does like an average arbitration cost? Just curious.
How much does arbitration cost?
Well,
How much you got? Spoken like a true attorney, Rob.
That's right. Well, and I'm not crawfishing a little bit, but it depends on how long it is going to take. It is mostly in hourly charges. The IYAC has its initial charges, and I believe, and I don't have the numbers in front of me. I don't, Paul, if you have a better thing, but they're the initial fees, and they are somewhat on a sliding scale depending on the size of the agreement, because it's the size of the amount of controversy, because a lot of the work that goes on. The arbitrators, you are paying much like attorneys by the hour. Usually they will set their rate, and so to a certain extent, you're buying, an attorney and a half or a broker and a half for that. So, 10 hours times, I don't know, $400 something an hour times 3 times do the math times whatever, you start getting to those numbers. Where the savings come in is because it is faster. Usually, not to use that old thing, time is money and such, but if it's, especially if there's a vote involved, the longer a purchase and sale agreement went bad, something's running up money. A U.S. District Court judge may say, fine, I'll see you next September, as opposed to, let's get this done within the month or something. That's where the savings come, where the timing, the timing of it is. We're not spending a lot of time on discovery and such. I'll be honest, I don't have a number on the top of my head. I probably should work that out. But on the other hand, it is not necessarily cheap, but neither is going to court. But this way, I'll go to the last thing Serena said, you are more in control. You are setting your own dates. You are picking your judges. It is more business-like, because even as Andrew said, you're sitting at the same table. This is someone you may have been doing business with before. The ones where you see some of the ones I've seen, commission disputes between brokers, yacht purchase and sale issues. One of the areas which is kind of a growing area is unhappy charterers. Charter contracts and such. I went your boat and you said it was beautiful and it was terrible and whatever, and I didn't like it, and I had, it rained. Well, that's not my fault. But some of you who've been involved with charters, you've heard more complaints than I ever will, where someone will say, I had a 10-day charter and 3 of the days were bad, or they didn't take care of me and such, and you have unhappy charters. And much of the charter contracts have arbitration clauses in there. And then the last part also is, we're also back to the privacy issue. I've seen it with charters where we have had unhappy charterers who do not want their laundry done in public, who may be, there was one, some of us were involved with years ago, but I remember someone said coming in, I do not want to hear anyone talk about this, read about this, see it in the papers and whatever, and which frankly, I didn't know who the person was in the first place, or something, so it didn't make a difference to me, but that type of thing. So
but I think it's important to give an answer too, because I think of everybody sitting in the room, that's probably the most important question, right? It's the first question you'd ask. So, and it is, right, it's complicated, but it's more further complicated by the fact that probably each of the 4 of us and everybody sitting in the room charges different rates per hour, right? And different rates for associates and paralegals. It depends on if there's a claim and a counterclaim, how many counts in the claim. There certainly is a time savings, right? And that's one of the key things there. But you might save some money in motion practice or whatever. But you can think if you get a cheap lawyer, and there's lawyers outside of this room that'll take cases for peanuts, right? Because they want cases. But you might get a lawyer for $10,000, and in the same case, I'm charging $60. It depends on the lawyer, right? But you're not going to be in it for that much less than litigation. And so depending on the complication, you're probably starting at 10. And you probably ending northwards of 100, just depending on how complicated it gets.
And the IYAC also has a simplified procedure, which is meant to deal with smaller claims. I'm not sure of the jurisdictional amount as far as, but if it's a simple procedure, the IYAC has a simplified procedure where it's done quicker. I think the rates are a little bit lower, and the procedure is a little bit more simplified in order to just get it done.
And frankly, at some of the training meetings, we've had some discussions among some of the arbitrators and some of the Europeans in terms of maybe working on the rates and such, either dropping them under our competition, things like that. In fact, I think they're under them right now, and things like that. But also to make it so it's more readily available. The good news with the clients, you are dealing with, mostly with high net individuals, you're dealing with larger sums. Most of them involving yachts and such, involving larger yachts. So a lot of times there's a great deal of money at controversy, so sometimes the arbitration is, I don't say the least of their worries, or the amounts, maybe the least of their worries.
So the panel alluded to the London Maritime Arbitration Association and the American Arbitration Association, and those were 2 groups that we looked at in the formation of the IYAC because they had an established structure of rates and an established structure of rules that have been tested over the years, have been proven many, many times to be very effective. We didn't reinvent the wheel here. What we did is we took very well-established protocols and applied them directly to the yachting industry. As Serena says, there's a small claims process. So if you have a $30,000 commission dispute, you're not going to spend $25,000 trying to win it, or $40,000 trying to win it. You've got the arbitrators are free to choose their own fee structure. Some attorneys charge $550, $750, $850 an hour. As an arbitrator, they may choose their normal legal standard fee. They may choose to charge a little bit less. Maybe they choose to charge a little bit more. It's up to them, and that'll be disclosed to you at the time that you want to investigate an arbitration. All of that information is available to you when you choose your arbitrators, whom you may want.
Any other questions? Oh, we got one over there.
Oh, I know one of the points that I was going to make, getting to you in a second, Roy, was that the amount of the claim will dictate whether we use a single arbitrator or a 3-arbitrator panel. So I believe if it's under $1 million, we use a single arbitrator. If it's over $1 million, it automatically is a 3-arbitrator panel. and each side chooses one arbitrator and the other, and those arbitrators choose the third.
In the 90s, I was an arbitrator with the AAA for about 5 years. I think an attorney recommended I apply, and I think it was Rob Maass, but I'm not positive. Every case that came to me that involved a boat builder or yacht broker, I turned down. I got one case that was a minor charter contract dispute, which should have gone to a lawyer, but both sides picked me, so I did it, and it worked okay. Then I got in a big case with a ship, a dockage facility, tugboats. I was very comfortable with the technical issues. The second arbitrator didn't have a clue on anything. And if the third arbitrator hadn't have been an attorney, it would have been a complete disaster. So I don't recommend you do any of the arbitration without at least one attorney. That was my observation. And I think the AAA paid a set fee, I can't remember, but it was quite a bit of money for the 90s. That's my observation.
Thank you, Roy. Just one other thing that we established during our initial training period was there were 6 attorneys and 8 non-attorneys in our initial training. And looking around the room at those that weren't attorneys, we recognized that there was a little trepidation on their part. So we made a command decision on the spot, and that is all non-attorney arbitrators will choose or be assigned a legal mentor for at least their first 3 arbitrations, or until such time as they're signed off by an attorney mentor. Because there are certain things as a broker or as a person in the industry, you may not have intimate knowledge of rules of evidence, rules of law, things of that nature. So we have attorneys that are certified arbitrators that are assigned as mentors for those that are not in the legal profession.
With the past MMAA being recommended for some changes as far as conditions and at least charter agreements, certain charter agreements, is it recommended that we use the IYAC now perhaps as a change in that language instead of the MMAA? If it's even, I don't even know if it still is the Miami Maritime Associations or Arbitration Association still in effect, assumingly. And if you do make these changes, can you also do it to a contract that is perhaps English law, for instance? Can you say, no, we'd like to, but then have perhaps a British attorney just as an advisor for that panel?
I think it's a yes to both questions. I mean, certainly, it is your choice, to pick who you went with. Obviously, for yacht type events, we would want you to use, this organization. Yes.
So as long as both parties agree, you can make those changes.
Right. Exactly. In fact, that's in that initial page. We choose this organization, the laws of this. Be it the laws of the state of Florida, the laws of England, wherever. So you make that decision, the buyer and the seller, and that's true in the contracts now. I mean, you make that call. I always say it used to be hidden under miscellaneous, as I used to joke about in the FYBA contracts. Choice of law, venue, location, jurisdiction, etc. So whether I sometimes say whether you know it or not, you already made. Once you've signed this, you've made the call. So look at it beforehand. And one of the last things that was funny, something made me think about in terms of amounts. Yacht brokers, yacht lawyers are not intimidated by large yacht numbers. And I think too many times, was it Billy Smith had a phrase, he referred to people on the docks as whistling gophers. I can't whistle. What does that go for? I was involved with the AAA arbitration, and it involved a large yacht, and I think they were just stunned by the numbers involved. And I also have a theory going to court that I don't think there's any less sympathetic person in a courtroom than a very large, rich yacht owner. And so, juries kind of look at that and just their eyes kind of glaze over. Wait a minute, we're here talking about this boat. while arbitrators who are much more businesslike and have dealt with this before go, yeah, it's a big yacht, what's the problem, or such. So I think that it becomes one of the other advantages of being here.
And you bring up a good point about choice of law. That's something that's very important as well in terms of when you're choosing your arbitrators, you would like them to be somewhat familiar with that jurisdiction as well. So that's an important consideration.
But I believe, don't we have English solicitors who are,
yes,
have gone through the training, right? So that even if you had, say, a IYBA contract and they wanted to keep the choice of law to be English law, you could still use the IYAC.
So if you use the PSA or the listing agreement, that is the form from IYBA at this time. Under Clause 17, you nominate, well, the default dispute resolution platform is the International Yacht Arbitration Council. If you do nothing at all, it's IYAC under the laws of the state of Florida, plain and simple. If you want it to be IYAC, but you want it to be in London, that automatically engages English law. Also, Monaco would engage English law unless you selected US law. You could do that, I guess. And we do have British attorneys. We have British, Dutch, Spanish, Italian. We're working on, well, no, we have French speaking, although not attorneys. We have attorneys, we don't have Dutch attorneys, but we have Dutch speakers. So we're working on rounding out our offering to be 30 certified arbitrators by the year end, and that will include French-speaking attorneys. And oh, by the way, our agreements are currently being reviewed for translation into French, Spanish, and Italian. And it's not so simple as taking an agreement and dropping it into Google and getting a translation, because it's all about the concept. Those four folks up there will tell you it's the nuance. The devil's in the details. So translating to a different language is not about this word translates to that word. It's about a concept translating. That's what's critical about it.
You know, we understand that the PS and the charter agreements are basically Florida and federal U.S. laws are all based on that. And I'm glad he brought up the international stuff, because I figured there were some international lawyers getting involved in these contracts. So is there any kind of like gray area in these PS and the charter agreements that sometimes international laws play into the arbitrator's decision? And also my second question is, where do you get your pool of SMEs during your debate your cases? So subject matter experts?
You catch that?
Yeah, so the first part is, if I understood it correctly, whatever's in the contract is going to apply. So if the contract says you're applying Florida law, then the arbitrators are limited to looking at that. You can make it say whatever you want. If you and I agree that we're going to apply Zimbabwe law because we like the way they build yachts or they deal with, yacht ownership, then we can agree to that. And then you've got to figure out how that works, right? Because that's what we're applying now. So that's one. If I understood, the second question was, where do we pull our experts from?
You're arbitrating a case. You're not going to use lawyers all the time, right? So you're going to use some technical experts on whatever. Where do you get your pool from the marine industry?
Well, I think for the IYAC, they've set their pool of who it's going to be. So until they open it up, if you're in IYAC arbitration, by the way I understand it, you're limited to that 30 by the end of the year or whatever it is. If you're a party to an arbitration looking for an expert, you can pull them from wherever you find experts. They can be brokers, they can be anybody that can be established as an expert in a field, can be used. Engineers, naval architects, and you're looking for somebody that you find is reputable that can support your case.
You bring up a good point in terms of choosing experts. Just like the rules of evidence are a little bit more relaxed regarding rules of evidence, the same applies in terms of who you choose to be your expert. Federal and state rules have heightened standards of who experts are allowed to be and what kind of qualifications would make somebody an expert. So arbitration, that's a little bit more relaxed as well.
Just make sure you pick somebody who can drive a boat, who can work on a boat.
That's right.
Question. So we've mentioned the PSA, the IYBA PSA, which is mainly for brokerage boats, so secondhand.
So is this council prepared to work also on new builds, like contracts involving new builds? So where the shipyard, the yacht builders is on the other side?
I think that this is, somebody correct me if I'm wrong, but I think this is designed for anybody. So businesses in the yachting industry, if you're a broker and I'm a broker and we agree to resolve our dispute, in front of the IYAC, I think that's what it's designed for.
New boat, brokerage boat. Yeah,
New boat,
anything.
brokerage
boat,
boat,
charter contract,
disputes,
yeah.
whatever it might be.
Unequivocally, yes.
Just make sure the language is dropped in there.
Right.
Exactly.
Right, you would put it in your contract.
Exactly.
Right, exactly.
I had a call from an attorney in California yesterday that asked me specifically for the language because he's preparing an agreement to make an offer to another group, and he wanted to drop in the IYAC dispute resolution language. In Europe, when we were over there in September, we trained 7 new arbitrators on the 17th, and then we had the Super Yacht Lawyers Conference the first morning of the Monaco Yacht Show. We had, I'm going to say 25, 30 European attorneys, yachting attorneys in the room, and Bob Allen, Gianfranco Pupolo, and I were pretty much inundated with questions as to where can we access the clause. So we've got the clause, if not at this moment on the IYAC.org website, by the time the sun sets, it'll be on there. But the dispute resolution clause is available to attorneys to insert into your agreements.
Right, but even if you didn't have that, right, and you're in a bar and you're writing this on a napkin, you can write, subject to dispute resolution with the Internet Yacht Arbitration Council, and you have to spell it out so we all know what IYAC is. But yeah, I mean, it's great to be able to drag and drop it in, but if you don't and you don't know what to do, just put it in there if it's something you think you want.
Okay, and I think just to keep things moving, we probably need to do the thrilling conclusion, Act 3.
We will, but I'm going to ask real quickly for the certified arbitrators that are in the room, please raise your hands. Gary, Jeff, Bob, Rob, Mike. Who else? We got one more. I saw others. Michael Moore is, Carol Wexler is, James Jaffa, Jay Tooker. We have a very well-rounded group that's very, very knowledgeable. And with that, cue video, please.
Hey, Joe Stanley. It's good to hear from you. It's been 30 days. Have the arbitrators reached a decision? They found in my favor. Okay, well, that's good. We're going to be awarded attorney's fees. That's fantastic news. So I've got to wait to collect. I've got to wait for Bubba to pay in order to collect. Oh, okay. All right. He's compelled to pay, but he hasn't yet. All right, well, I guess that's still good news, but I appreciate the news. Thank you so much, and please keep me posted on if anything hits. All right. Thank you. Bubba, you have forced me to drink heavily. And now I'm going to drink some scotch. Lots and lots of scotch. Bubba, I will get back to you. Or I will get back at you. Maybe in the form of a lawsuit for liver damage and stress, heart disease, whatever it may be. I will get you back.
Boy, let me tell you something. If you don't learn to suck the eyeballs out of damn ballyhoo and spin them over, they're always going to spin. It's always going to look like you got 4 propellers riding behind your boat. You ain't never going to catch nothing. The key is you got to make your baits swim. They got to, look, I got to go. Shit, I'm all ready for game day picking up my shirt. All right, I got to go. Bye. Hey. Oh, hey, Chad. Chad, what's happening? How are you, man? I've been waiting to hear from you. Yeah? Lost the arbitration? How could we possibly have lost the arbitration? I told those boys what was for. What? And now you think you're gonna sue me for professional negligence? Are you out of your mind, Chad? Boy, let me tell you something. You are a neophyte, and a neophyte got no business working in a big man's world. I'm gonna teach you a little thing about you gonna come after me for professional negligence? I'm gonna go Denny Crane on your ass. Goodbye, Chad. God damn it. Damn it. Jesus. God damn it. God.
Okay, so Michael, I'll start with you. The arbitrators have made their decision. What do they do?
One, either payments are made voluntarily. Two, sometimes depending on the nature of where people are located, the size of the dispute, money may be put in escrow beforehand if, by the parties. So one for the cost, so to make sure that the panels get paid, the costs are made. And there may be a demand that depending on how much is that money be put in escrow, so we know there is something to collect against. And the last thing, if it is not, if one side, if Bubba decides not to pay, an arbitration award is enforceable much like any other award by a court. If someone gets a judgment in court, the court turns it over, you can take it to the sheriff or the US Marshal or whatever who will collect on their goods. Arbitration awards can be taken to a local court and they turn it into a judgment that is enforceable by the sheriff, the US Marshal and such. I mean, arbitration panels don't have their own set of people to go out and take your car in the middle of the night. And arbitration awards are generally enforceable almost automatically because a complaint is filed. There was an arbitration agreement, an arbitration was held, here's the award, judge, please turn it into a judgment. The judges sometimes look at it again as, you guys agreed to it, you paid your money, you took your chances, and short of, bias, fraud, manifest disregard of the law, which no one's really sure what that means sometimes, they're enforced by the courts. The court turns around just like any other judgment. They'll turn it into a judgment, and off it goes.
And the IYAC rules provide, at least for default, for a reasoned award, right? They have to explain themselves.
Yes, and the awards are given, maybe backing up, written awards, they don't have to be, very detailed, but it's, arbitration was held on Tuesday, we heard the following facts, therefore we rule that in this case, the fault is, the boat was given to the buyer and there's no fault on the part of the seller or the broker. Therefore, the claims against the broker and the seller are dismissed. Plaintiff will go, and they will be, and if, I don't know if this is jumping ahead, if the contract called for attorney's fees, the underlying contract, which most of the purchase and sale agreements do, the arbitration panel has part of that award, can determine the amount of attorney's fees and costs, and that'll be put in the judgment too. And then it's enforceable like any other judgment.
So we'll get to attorney's fees, but first, Andrew, I want to ask you, do you have experience chasing people to enforce arbitration awards?
We do, with court and arbitration. And, so these things generally do travel, like Mike said. They are enforceable here or wherever you might go. Not necessarily everywhere in the same way, but for the sake of this panel, assume that they do travel and that they're enforceable wherever you go. So you may need to take it to a local court, localize it, and have that sheriff or marshal, as the case may be, go out and sticker somebody's house or whatever it might be. Their property to garnish bank accounts, whatever the case may be, to get your money back. It's not always easy. Like Mike said, a lot of times we're looking to get the money up front if you can do that. In some cases, I may get an award against you and you can't pay. And you say, well, I don't have $100,000. Okay, so now I'm forced to chase. But you say, but I'll pay you $10,000 a month, for the next few months. And so maybe we agree to that. But it's something, you should have that discussion going in. That should be part of your reasoning before you ever enter an arbitration. How are we going to enforce this thing when we win? Because nobody thinks they're going to lose. So how are we going to enforce this when we win? And then you have the mechanism in place to do that.
Okay, Serena, attorney's fees. We know that the American rule is each side pays their own attorney's fees. How is that different in arbitration?
Well, like many things in arbitration, it depends on what the contract says, right? You see a theme going. So basically, the same contract that started the arbitration in the first place, see what that contract has to say about attorney's fees. Again, the default rule is that everybody pays their own fees, but some contracts will also have a prevailing party fee, meaning whoever wins, the other side gets to pay their attorney's fees as well. Sometimes it can get dicey when, for whatever reason, if the arbitration kind of tries to split the baby in half and it's not necessarily clear who the prevailing party is, that can get a little complicated. But that could also, the arbitrators have the discretion to determine, you know what, since we kind of split the baby, everybody just goes their separate ways and everybody pays their fees. But again, it's always governed by what the contract is and what the parties agreed to ahead of time.
Michael, if there's no fees provision in the contract, do the arbitrators under the rules have power to award fees to one side or the other?
They have the power to award fees, but I think sometimes the default position, usually by arbitration panel, seems to be, and what did you two agree to? Oh, it was in the contract.
Right.
So it almost comes back around in a circle.
So that's, I mean, we've talked actually about a few different things that you want to have in a dispute resolution clause. One is where are we going to hear the disputes, arbitration or court, what law is going to apply, and then also a fees provision, who's going to pay attorney's fees. Okay, the other thing I want to talk about is, let's say you get an arbitration award and you don't like it. You think they're wrong, or you think they were biased. On what grounds can you challenge it, and how is it different from your ability to appeal a judgment in a trial?
Okay. Second question first. American court system, we have, or at least the federal court system, we have the district courts, we have the courts of appeals, and we have the Supreme Court. In the arbitration, you have the arbitration panel. That's it. There is no appellate division of the International Yacht Arbitration Council and such. There is a provision if someone made, a math mistake or something like that, but it's not an appeal of the whole thing. The only way it's arbitration awards, anybody's arbitration awards are, if someone challenges it in a district court, is got to be some sort of almost collusion, fraud, bias, and that's almost, one, it's very hard to prove. Generally with the conflict checks, it's known, something's known going in. Has a general rule, arbitration awards are upheld. I mean, you got to be pretty far off into the weeds in order to come up with, say, he took money, or something like, I didn't mean to pick at you, or something like that, or, she's my sister-in-law, something like that, those type of things. But as a general rule, that's the decision. And that gets to the speed part of it, the whole part. We're not putting this on into a future. And then one of the things talking about costs or just money and such, oftentimes with purchase and sale agreements, charter agreements and such, there may be money in escrow that's being fought over anyway, in terms of, I want my deposit back, or, charter fees or things like that. So sometimes that money is already there waiting for you because you have that, again, that business relationship beforehand, as opposed to two cars who ran into each other.
But just as a practice point, don't hear him saying, these things are not appealable, they're final, as like an open invitation to create fraud, like you said.
Yeah, okay, sure.
Nobody in this room, of course, because you're all in the room,
No,
but certainly people in the industry would be like, okay, I'm going to hold out this key piece of evidence
exactly.
because nobody's going to find out. They can't appeal it. That would be fraud.
That would do
be
it.
subject
That would do it.
to
Yes.
an appeal, right?
Okay.
So I think that's an important point, that it would have to be sort of misconduct in how the arbitration was conducted. The fact that they made a mistake of law, something that you could maybe get reversed on appeal, you're not going to be able to avoid an arbitration award because of that.
No, correct.
And in many ways, that goes to one of the advantages of arbitration, which is finality, because you don't have the ability to drag out the dispute with appeals to higher courts. You get a decision, one side pays, and it's over. Serena, do you have experience challenging arbitration awards, or have you had clients who were frustrated, you had to explain to them how they couldn't challenge an arbitration award?
Those are conversations that I usually have ahead of time, so I don't like my clients to be surprised by anything. But that's usually one of the first conversations that we have. Look, at the end of the day, this is something that was decided beforehand, so it is what it is. But I do like to let my clients know in terms of this is something to be aware of, but also an advantage as well, because Sometimes if you win arbitration, then it's over. If you win in litigation, that's just, you're halfway done, because now there's going to be an appeal. Oh, by the way, you won, but guess what? Now you have another 9 months on appeal. So definitely having arbitration, having some finality to it, it helps with duration and cost as well. But as far as challenging arbitration, I agree with Michael in terms of it's very tough to try to open up the merits again with a court. They are just very deferential to arbitration now, the same way that they're deferential to refer things to arbitration, the same way in terms of enforcing arbitration decision.
There's been just a series of Supreme Court decisions in the last 20 years or so upholding different kinds of arbitration agreements, things like class action waivers and consumer arbitration. You know, everyone in this room is probably subject to 20 arbitration agreements that you don't know about. Because every time you click, yes, I agree to the terms and conditions, there's a good chance there's an arbitration clause in there. And by and large, those are enforceable. Every time one of these cases has come to the Supreme Court and it's been challenged, they say, look, Congress enacted the Federal Arbitration Act. They want arbitration agreements to be enforceable. We're going to keep enforcing them. Congress can change it if it wants to, but to date, Congress hasn't shown any inclination to change that. So arbitration agreements, as a general rule, the agreements to arbitrate are enforceable and the awards are enforceable once they're made. So with that, I wanted to leave a little bit of time for questions at the end. So if anyone has any questions about either the third segment or really anything. Yeah.
Thanks. Hi, guys. 2 questions, and they sort of go together. Will the IYAC be issuing reasoned opinions with the awards, or are they just a boilerplate, you know, win-lose sort of opinion? And if there will be reasoned opinions, will there be an anonymized award library or opinion library that lawyers can look to sort of develop a, you know, playbook of potential of victory going before the IYAC?
That's a fantastic question. Mike?
Mike Karcher of counsel to IYAC.
Yes.
Happy to answer that
Working,
question.
first question, yes, I like the idea of reasoned opinions. 2, in some of our discussions, we've been a little, you know, privacy is still the #1 thing in terms of, you know, we don't want to say, you know, this broker, you know, one lost against this, you know, against this buyer lost their one against this seller and such, because one of the main things we have been pushed on was we have clients who want privacy. So the idea of having blank, you know, I like the idea though of having, you know, maybe putting together kind of a blank library and such where you don't know the names of the parties and such. You know, the names have been changed to protect the innocent and all of those things. I think that's a good idea. But we're not publishing it in the sense so someone can go back and say, hey, this rich yacht owner, you know, was sued by this rich charter company, you know, charterer, and they were unhappy about something. Those we definitely want to avoid.
So one of the knocks on arbitration generally is that, you know, we're in a common law system. Precedent is really important. And some people say arbitration inhibits the development of precedent because you have all these decisions that aren't published, that are essentially secret. And so, for example, in the US, the law of charter parties has basically disappeared from the courts because so many of them are handled by arbitration. The good news is there's no body of law, developed law for yachts anyway, so there's not much to inhibit, but I do like the idea of having the decisions available without identifying information. That would be really helpful.
And a good practice tip for people that are before a panel is to ask, and I've never seen an arbitrator deny this, in terms of asking if you can submit findings of fact and conclusions of law. And that way each party submits their position as far as facts and law, and the arbitrator, it's less work for the arbitrator, but it forces them to actually basically create their findings of fact and conclusions of law so that you do have a reasoned opinion.
And that's true in any court, the idea where the judges are saying, please, you know, each side submit your legal briefs and such, and let them make the decision. So less work.
So I'm not confused by the presentation, but this caused me to look at my contract. In fact, I sent one out yesterday. And so now I'm confused by my contract. Because prior to this, it used to say a court of law, and it was folded in as Broward County. That's what it used to say. So could you humor me and let me read like 5 lines? Okay. Let me get my glasses right.
Nah, I've got good glasses. I just got a still small print for this old guy.
You got 4 lawyers on the clock here, John.
Yeah. You got 4 lawyers, so you're going to get 6 answers.
Yeah, that's
Yeah,
okay.
sorry.
One of you will give me a great answer, I'm sure, or all of you will. Oh, shoot. I wish I put my finger on this.
Clause
thing.
17.
Agreement will be brought into the courts of the state and county of the main office of selling broker, and each of the parties irrevocably submits to the exclusive jurisdiction of each such court. Waivers any objection, it may now be hereafter have a venue or to, convince a forum, and agrees not to bring any proceedings relating to this agreement to any other court. Then it says, the additional terms in the info box above shall be incorporated herein, and then in bigger, bolder, italicized print, it says, the parties have been advised to consult legal counsel with respect to the agreement, hereby waive trial by jury with respect of any
not one of ours,
claim
is it?
relating to this agreement, whether against each other or against the broker as a third-party beneficiary.
Great.
So is that saying that we're going to arbitration? Is that what that's saying? No.
No, that's
No,
just,
that's not one of ours.
That's just a standard dispute resolution clause. So what Paul's suggesting is that you would pull that out of your contract.
Okay.
And you would insert, if you want IYAC dispute resolution, you would insert their pre-approved language.
So that's basically saying wherever the seller broker is located, their main principal place of business, that's going to be the jurisdiction of the court that you're going to select. So that is.
That last line counteracted that, saying there's
no, it just means it'll be a.
So let me clarify a point. That's not the IYBA agreement.
You're right. I was going to say, that's not, I was going to say,
So
I said,
here's-
sounds great. It's not ours.
Here's something that's very important for everyone to understand. Thank you, Julie, for bringing this to my attention and reminding me to tell everyone. We have revised the IYBA agreement as of late September, maybe October 1 is the latest revision, because we actually revised the revision. But paragraph 17 of the IYBA agreement nominates the IYAC as the default dispute resolution platform, has no reference to the courts. You're looking at an agreement that's used by your company, and the language, we have no impact on the language used by any company. You know, your company may have employed Mike Karcher to write the agreement, and Mike Karcher wrote an agreement specific to what the leaders of your company said that they wanted in the agreement. You could agree to solve your disputes by the rules of the Mickey Mouse Club at Disney World, if that's what the parties agree to. Under the IYBA, the agreement that we have copyrighted, which is illegal to change, nominates the International Yacht Arbitration Council as a dispute resolution platform. If you do nothing at all, it stipulates Fort Lauderdale and the laws of the state of Florida. If you choose, you can indicate London and Monaco, or Monaco. You can choose British law if you'd like to. Or you can, by addendum, nominate the courts if you hate your money and
So
that's where
there's a
you want
couple
to go.
things there too, right? So if you don't want IYAC, which everybody here should want based off this panel, if you don't want it, you got to know that that's the default now, one. And two, as somebody who represents a lot of companies in the industry, if you as a broker are saying, hey, I really like this IYAC stuff, I want to take it in my XYZ Corp contract, I'm going to start putting it in my contracts. Don't do that on your own without talking to your employer, right? Because, you know, now you're changing
And your attorney.
impact for your company, right? Because now if you as broker one are using a different contract than he is, that can impact us in litigation down the road. So, you know, just be cognizant of it.
So in my own little defensive mode, I was under the impression my company was using the IYBA contract.
Right.
That's it.
There you go.
Question.
It's those pesky back pages that everyone talks about. Yes.
Well, guys,
But
yeah.
Yacht Closer is not an IYBA company. Yacht Closer is an elegant platform. It is a private enterprise. And in Yacht Closer, you will find IYBA, you will find IYBA, you will find if your company, yes, that's right. If your
can have
company
anything.
uploaded or paid them to format whatever form that your company wants to use, then that's the one that happens. And in their onboarding process, when John Keenan signs on, John Keenan automatically utilizes the forms that his company dictates.
I still thought that we authorized Yachtworld to IYBA.
I'm going to talk to your boss.
I like that. Talk to him.
Anything else?
I just wanted to let everybody know that the one way to check the version of your contracts is on the bottom. You will see a little footer that says 9/29/21. And also the trademark at the bottom will also have the 2021. So look at your versions of the contract to see if you have the most recent version of the IYBA contract that has this language in it.
And we submitted the latest revision of the contracts to Yacht Closer a couple of weeks ago. And thanks Gary Smith for a lot of help in this regard. We've been getting some very good response from Yacht Closer with formatting these documents. It's not something as simple as uploading a PDF. Kelly might be able to enlighten us a little more on that, but it's not something so simple as uploading a fillable PDF and boom, suddenly Yacht Closer has your forms in it. It takes a lot of formatting and mapping. As everybody knows, I'm not an attorney, but the other thing, as Julie just mentioned, at the footer of every page in the agreement, if it is the IYBA agreement, it states very clearly that this form is exclusively for the use of members of the IYBA and is copyright protected. It has that little C with the circle around it. If I'm not mistaken, the minimum penalty for copyright infringement is $5,000 per occurrence. Is that correct?
Not a copyright lawyer.
Well, that's what the guy I paid to copyright it told me. So, right, Serena?
And if it's a real,
something like that.
if it's a real IYBA contract, when you hold it up to the light, you can see a picture of Paul.
Yeah, that's right.
Bubba. You see Bubba Calhoun. No, it is watermarked IYBA. And the reason that we copyrighted that agreement is so that you, as members of IYBA, can receive an agreement from someone else and know that it has not been modified other than in the fillable boxes. If it has been modified, down the road something goes wrong, it's found out that it was modified from its original form, you're protected.
Ooh, cool.
That's a loose interpretation of what the copyright does, right? It protects you from someone else modifying it.
Well, it protects your ownership of the intellectual property in the agreement. I don't think, I mean, interesting question. If somebody took the form agreement, modified it, and didn't, and sort of concealed it, would that be considered fraud or provide any grounds for avoiding the contract? I think probably not, but
I don't think so.
I don't know the answer to that.
I don't think so.
You'll get to sue.
So in all three sections, you spoke briefly about, the ability to subpoena, the use of records and documentation during the deliberations and even in the awards. There was some discussion about the documentation associated with the contracts. What record-keeping obligations, we as brokers all know we have a whole bunch of records we have to keep on any transaction, but what record-keeping obligations do the arbitrators look for in terms of documents that either party should be able to produce associated with the transaction? And then, if they don't keep them, say there's sloppy record-keeping on one side or the other, how does that affect, A, the cost of the arbitration, but B, does that, I guess what I'm talking about here is discovery or exculpatory evidence or whatever. How do you treat that during the arbitration and the cost associated with producing those records? I don't know if that made sense.
They will.
Go take a shot. Go ahead.
I don't think that there are any sort of affirmative obligations in terms of record keeping, aside from just whatever you're subject to normally and whatever best business practices are. It's not as if there are special record keeping obligations associated with arbitration. I think generally the arbitrators are going to look at what are your record-keeping practices? Did you comply with them? And if you don't have the document because as part of your normal practices, you wouldn't keep it, that's one thing. But if you should have it and you don't, that's where they would draw an adverse inference. And in general, just having, obviously a robust record-keeping operation is better because it's going to make these disputes easier to resolve later on if the information is available. But I don't know that there's anything particular to arbitration that is going to impose additional obligations to keep records.
One way to create a duty is sometimes litigators will send the other side a preservation of evidence letter. That will say, look, at least from this point on, you are being notified that there could be a lawsuit or there could be a dispute, and you are being asked to, whatever you have at that time, to please preserve that evidence. And they'll usually have a list of things that they expect you to preserve. So that's the only time that maybe a duty can then be imposed upon you.
And is that pre-arbitration, or is that once you get into I mean, that preservation letter, that sounds like the beginning of a civil process where we're going to go to tort claims court and stuff, right? Mm-hmm. So if we're already obliging ourselves to go into arbitration, what does the arbitrator do in terms of preservation of evidence or demanding documents or requesting them politely? I don't know.
I think it's safe to say if proceedings have started with court or an arbitration, please preserve anything at that point on. That's not a good time to start getting the shredding machine.
Yeah, okay.
So once you know for sure that a dispute is happening, just cool whatever impulses are. Get rid of things.
All right, an insurance question, because it seems very insurance related, this particular event that happened, lightning strike and fireball blowing up and things. And you did actually say this was based on a true story. Was that actual? No. Okay, never mind. Okay, but does insurance ever get involved in this arbitration? And can you talk about that?
Yeah, but the short answer is, we give you one of those lawyer answers, it depends, as Rob said earlier today. Normally, the insurance companies have not signed on to it. It's usually if there's a contractual dispute between two parties, buyer and seller, charter or chartery, and such. There may be insurance implications on it. In this particular case, when it was, it seemed to be who had the risk of loss, buyer or seller. I don't know if your question is, is sellers insurance suddenly off the hook because of an arbitration award? The answer may well be yes, because it's can be shown as someone has made it. Most insurance contracts do not have arbitration clauses and such in it. This may be a way to just put it on the buyer. I don't know if you're looking at it. Can the buyer's insurance company kind of challenge it and go back around? I think they'd have a very, very difficult time because a decision has been made between the buyer and the seller. Regarding the buyer and the seller, an arbitration panel has ruled that it is not the seller's risk of loss, primarily in this case. So the buyer's insurance that may or may not have may be on this. Is that where you're going with this?
But also, if you have let's say you're a company that got sued and you think you're insured for the claim, right? You still want to notify your carrier, and your insurance company may very well have a say in your defense, right? They may even appoint.
They may even pay for it. Yes.
Right. Right. So don't just assume because you're in arbitration that doesn't work, or that you don't need to notify them until the end. You still want to allow them up front to have a say in the claim.
Mm-hmm. Well, and one of the ones I see it a lot is a lot of CETO, towboat, U.S. contracts have an arbitration claim, but that does, even though there's an arbitration clause, but that still triggers someone's insurance generally, where the insurance company, jumps in on behalf of it, and they're the ones paying for it. So if it's a boat owner who's, CETO shows up, hi, you have a problem, please sign this. That their insurance, boat owner's insurance, even though they may be subject to an arbitration clause, is going to defend on their behalf. So to that end, that's where it kind of links. That's probably the most common case where it links up.
We're going to try to stay on track here, so if you have additional questions, please feel free to corner one of the panelists afterwards. Thank you, gentlemen and lady, very, very much. I'd also like to thank you.
Thank you very much. Enjoyed. Thank you.
Mr. Bill Boatwise, Grant Henderson on the far side of the room. You can get his autographs later. Bob Saxon, Jeff Stanley, and Rob Karen, our arbitrators, and Joe Stanley and Michael Moore in absentia. Thank you very much for your participation and help. And Lee Savage from Between Two Yetis, the man behind the camera who makes it all happen. Thank you very much. And Bob Saxon says you can go take a break, have a cookie, have a soda, relax, stretch your legs, and come on back for the conclusion of Yacht Sales and the Law 2021.
This is yours.